Tonight's on meetings, and it's a fun topic. The second half, pretty much, will focus on parliamentary procedure, in particular, Robert's Rules of Order, which is the most common form of parliamentary procedure used in the United States. In Canada, by the way, most of their associations and corporations use something called Sturgis, which is actually much easier to read and understand than Robert's Rules, but for whatever reason, and I'll talk more about the historical development of Robert's Rules and who was this mysterious Colonel Roberts, okay? Now, what we'll start with is talk about the types of meetings that generally go on in community associations, the notice requirements. Now, my colleagues are gonna make fun of me because I apparently pronounce quorum wrong. I say quorum, like kind of like corn, but quorum. And I recognize that it's correctly pronounced quorum, but for whatever reason, I say quorum. So we'll talk about quorum. Meeting minutes. Now listen, folks, this is one of my best lines I've ever developed, okay? When it comes to meeting minutes, remember this, they are minutes, not hours. And we'll talk about that. They should be short and concise and simply be a record of the action taken at any type of meeting. And then we'll leave a few minutes for Q&A. Bruce, I feel like you want to say something.
We need a laugh track, I think, so that like when you make a joke, we can play like a laugh track so it's not so awkward.
I know what's funny is I try to look at people's facial expressions. Toby, I can tell you enjoy some of my jokes. Now, Ken Miller here has heard me present, I don't know how many times, not only in his capacity as a board member, but also as a real estate agent. And he's probably heard some of my jokes 20, 30 times.
Yeah.
Yeah, see how
they get better.
They get better. Yeah, they're like wine. They get better as they age. All right. Now, a couple of caveats, statutes versus governing documents. When it comes to meetings, your bylaws generally are going to have the requirements for notice and the types of voting that you can use. When we go through this presentation, I often, I'll when I talk about quorum, I always say 20%, and that's just the statutory default. And I know some of your documents, your quorum requirement is 50%. Some of you, I've seen your quorum requirement is whoever shows up at the meeting, which is a very small quorum. So just keep that in mind. Your governing documents are generally going to address the requirements of the things we're talking about. If they don't, then you go to the statutory defaults. Now, here's a good example. And some of you are in Washington, some of you are in Oregon. This is from Oregon. And it says, unless the bylaws say otherwise, your quorum is 20%. So if your bylaws say quorum is 10%, it's 10%. If it says it's 50%, it's 50%, okay? All right, now this is a quiz. Whoever gets this right first, Bruce Lepore will take you to an all expenses paid steak dinner, no limit on cost whatsoever. Here we go. Now, Bruce allegedly, I've never seen proof, was on the Maryland State math team. But often when I ask him these fun little questions, he doesn't get it right. So I'm like, were you really on the Maryland State math team as a juvenile? And I'm not sure. Here's the hypothetical. There's 200 lots in your association. You're at a meeting of the owners, and 100 of those 200 lots are represented. Something gets put to a motion and then to a vote, and 97 folks say yes, 3 folks abstain, okay? Here's our fact pattern. Now, we're at the meeting, we turn to their bylaws and look at whatever the voting requirement is for this particular issue, and let's suppose the bylaws say this. In order for whatever it is to be approved, a majority of owners present in person or proxy at a meeting. How many folks need to say yes?
Top one.
51.
Yeah. 50.
Now we're talking. So majority of owners present. So we have 97. So it's a majority of 97. Or actually, no, I'm sorry. It's a majority of 100. There are 97, there are 100 people there, so it's 51%.
Yeah.
Now, let's say instead the documents say, in order to be approved, a majority of votes cast by owners present in person or proxy at a meeting. This is where I'm trying to trick you because of these abstentions. It'd be 51% of 97. Bruce, what is it? I know you're on your calculator. I just saw you.
No, I'm actually taking notes on trivia questions to ask you about Robert's rules when we get there.
Oh,
Anyway,
okay,
51% of 97 is 49.
there you go. Okay, now, let's say instead the bylaws say, in order to be approved, must be approved by a majority of all lot owners. How many folks need to say yes?
A majority?
101.
Yeah, 200 lots. 101 folks must say yes. So I do this to illustrate that a slight change in language completely changes the voting threshold. So it's very careful, very important to read those voting requirements carefully in your bylaws, because sometimes it is a majority of all owners, sometimes it's a majority of those present. So pay very careful attention to that.
What if the bylaws just say all decisions we made by majority vote?
Ah,
Then
you
which
asking me?
one- Then which one do you use?
Majority vote. The default would generally be majority of all of the voting rights available in the association. Do you disagree, Bruce?
Sure.
You know, you can't ask a trivia question if you're not certain of the answer.
I think it depends on the context.
I think you're right too. And you're right. There are some bylaws where Bruce and I have, very carefully over and over read and trying to figure out what did the author of this provision mean. And sometimes you have some ambiguities and sometimes it's difficult. Ron, how are you doing? I haven't seen you in a while. Ron went to high school with my sister. Small
doing
world,
quite
isn't
well. I'm doing quite well. Been
Good.
busy in my regular job on top of this job.
it? Busy. Well, good to see you.
Yeah.
So
Yeah.
now in your community, there's going to be 4 types of meetings, sometimes 5, and it depends. Maybe you'll have more, but there's generally your annual meeting, which is a meeting of the owners, a special meeting, which is also a meeting of the owners. And the number one reason that special meetings of the owners are called generally is to remove a director. So those aren't very fun meetings. And then you have board meetings and committee meetings. You might have separate ARC meetings. Now you might think, well, it's pretty obvious what type of meeting we're talking about. But let me ask this, is there such a thing as a special board meeting? There is
Maybe.
not. There is not.
Sure there is.
Okay, Bruce, technically, just hold your horses. Let me make my point here.
Okay.
Um,
Point of order.
Actually, no, Bruce, I'll challenge you. I guarantee you will not see bylaws that ever use a phrase special board meeting. There might, maybe emergency.
Emergency.
But-
No, I think you will. I think sometimes you'll see bylaws that say that the board will have regular meetings. And then anytime the board would call a meeting outside of that regular schedule, I think would be considered a special meeting.
Maybe considered, but the documents generally don't identify it as that. But in any event, here's why it's important. Because the type of meeting dictates who constitutes the assembly. Now, let me explain. At an annual owner meeting, the assembly, and that is the group of individuals entitled to make motions, to participate and vote. So in an annual meeting of the owners, the assembly is all owners. And you as a board member, when you're at your annual owner meeting, you're really there in your capacity as a lot owner, not as a director, but any owner can make motions, vote. That's the nature of an annual meeting, and the assembly is all owners. Now, fast forward, board meeting, the assembly is only the directors. Now, why it's confusing is that most board meetings, the owners, your documents or the state statute requires the owners to be able to be present during the meeting and listen, but they're not part of the assembly. So owners at a board meeting, unless they're directors, don't have any authority to make motions or to vote But generally, most of these board meetings, you're gonna have an open owners forum at the end where owners can make comment, and that's fine. But in terms of decision-making and voting, at any board meeting, owners they're not part of the assembly, okay?
You
Now-
just be aware though, under WUKIWA, there is a specific requirement to have that owners forum, to have an opportunity for owners to address the board at a meeting. But
Real
that's the only-
quick, Kiowa, Bruce just mentioned, Ron and others of you in Washington, we're gonna do a special training seminar for Washington folks because Kiowa, what, we tell everyone what that stands for? Bruce?
Washington Uniform Common Ownership Interest Act. So it'll apply to all planned communities and condominiums in Washington that were created on or after July 1st, 2018. And it's going to be retroactively applied to other types of communities in Washington, but not until 2028.
Yeah, so be on the lookout for those of you in Washington. Now, why does it matter? The notice is going to be very different. So for an annual meeting, most of your documents require notice to be sent not more than 50, not less than 10 days. But for board meetings, most of your documents say at least 3 days or 72 hours notice. For special meetings, it could be very different. Often it's similar to the annual meeting notice requirements. And then some meetings, like committee meetings, often there's no notice requirements at all for certain committee meetings. Now the quorum is going to be different too. So in an annual meeting, your quorum is going to be identified in your bylaws. And it's also going to be identified for director meetings, and it's usually a majority of the directors will constitute a quorum for a board meeting. Now, we've talked about the assembly. I'm going to talk more about quorum in a minute, but here's my next trivia question. If you're the chairperson of your association and something gets put on the floor as a motion and it's now time to vote, can the chairperson vote? Or do they only vote to break a tie?
Yes.
Yes.
Is-
Which,
is-
well, I didn't hear that. What's the answer? Anyone?
Yes.
They only vote to break a tie?
No, it's just.
No, she's saying yes, they vote.
Oh, they vote. Yeah. The reason I bring this up is Robert's rules actually does have language in it. It says the chairperson generally only votes in the event of a tie. But keep in mind, that's in a situation where the directors and officers are different human beings. And one of the weird things about all of your associations, very different than corporate America, is that almost always the directors and the officers, it's the same group of people. The owners elect the directors in turn amongst themselves elect the officers. So at a board meeting, when it comes time to vote on something, if you're the chairperson or the secretary, when it's time to vote, you're not voting in your capacity as an officer. You're a director and you're supposed to vote.
What's another one?
Okay? I'll talk more about, so yes, in most cases in community associations, the chairperson always votes. I have seen some bylaws that actually say the chairperson only votes in the event of a tie, but absent that, chairperson votes. They're a director. They should vote. Now let's talk about open meetings for a minute, and this will apply to board meetings only. And open meetings require very similar to the open meetings requirements that school boards have or other public bodies. My dad is on here. He is in his 4th term as an elected official in Clark County, Washington. He's one of 3 sewer commissioners. I know it doesn't sound very glamorous, but it's a very important job because sanitary disposal is critical to civilization. Now, when he meets, the 3 of them, they have the same similar open notice requirements. Notice has to be provided to the public. Any member that wants to can join in person. They now do it via Zoom. And so this idea of an open meetings requirement, here's the policy behind it in your association is that owners are entitled to listen, to observe the deliberations and the discussions among you board members and see how you vote on things. So that's why if in between board meetings, all of you start circulating emails that say, yeah, let's go ahead and hire and sign the contract for XYZ landscaping. The reason is, provision 4 is really limits the scope of work and our cost actually won't increase. And then all of you do a reply all and say, let's do it. You've just violated the open meetings requirement. That type of discussion, deliberation, debate should be done in an open meeting where the owners have the ability to be present. Now, most cases, the definition of a meeting is any time a quorum of the board convenes and discusses association business. I'll give you an example. Let's say me, Bruce, and Allison are the directors of our homeowners association. And one night, the three of us happen to be grocery shopping. And I see Bruce and I say, hey, Bruce, how you doing? And Allison comes around the corner with a shopping cart. Hey, guys. And then we just start chatting. And then we start talking about how one of the neighbors is so far delinquent on their assessments that we really got to turn it over to an attorney for collections. And then Bruce says, I don't know, let's do a little more. We've just filed that first of all, that's a meeting. It's by chance, but it's a quorum of directors and we have convened in person. And now we've started talking about association business. Now, unless we have provided notice to all of the owners that we were going to be at the grocery store at 8 o'clock on aisle 12 to discuss, we've just violated the open meetings requirement. Okay. All right.
Couple questions in the chat, Kevin.
Fire away, Bruce. Do you see him? I can't see him because I.
Can the chair make a motion?
Yes.
Okay, can the board hold an executive meeting consisting of board members only to discuss owner personal information such as delinquency and how to proceed with a lien?
That's a perfect talk about the exception to this, Bruce.
For executive sessions? Yes, you can go into executive session and adjourn the meeting, close the meeting to owners for 1 of 4 purposes. So one of them is exactly the one that was asked, which is to discuss collections of assessments. Another is to discuss personnel employment matters. Another is to discuss the negotiation of contracts with third-party vendors. And then the fourth, which is my favorite, is to consult with legal counsel.
That's the best one.
It's like you're free for all. You can always call up Kevin or I and meet in executive session.
Now, Bruce, let me ask you something. Do you make decisions in executive session?
You make absolutely no decisions in executive session.
You know what? Look who just piped up and said, no actions allowed though, right? Norm Harker, Clark County public official, Norm Harker, that is right. They have like I said, these open meetings requirements that govern you, they're modeled after the governmental agencies and all of that.
Yeah, so and when you go into executive session in Oregon, as opposed to in Washington, statutes actually have some procedural requirements that Washington statutes don't have. The chair is supposed to state with as much particularity as possible the purposes for going into executive session. That is supposed to be noted in the minutes. The chair is also supposed to state when the matters that are going to be discussed in executive session may be disclosed to the members. And the directors do have to vote to actually go into executive session. So one of the directors makes a motion to move into executive session and seconded and voted on.
So, but remember, no decisions in executive. And again, the idea is you're discussing sensitive topics, things that you don't want members of the association to be listening to for privacy reasons or legal reasons, those types of things.
Caitlin has asked, are executive sessions documented in the minutes? The fact that you moved into executive session and then moved out is noted in the minutes. What's discussed in executive session does not have to be noted in the minutes.
And in some cases shouldn't. Years ago, we were representing an association in some litigation and saw their minutes that had been approved, and they did a summary of the executive session discussion between the lawyer and the board. That waives privilege.
Good.
So no, there's no requirement, and in most cases, you probably shouldn't put a narrative of what was discussed. Simply, you adjourn to executive session and state the general nature of why.
We have another question. Audrey's asking, are all so-called board meetings always considered open? Can board process be discussed without meeting being open? So
Oh,
anytime that a quorum of directors convenes to discuss association business, that's a meeting. I'm not sure.
can I say something about that, Bruce?
Yeah.
Maybe the question, so if you remember the purpose, it's to observe and listen to discussion, deliberation. And so I always get this question, well, does that mean we can never email each other? And I always say, well, hang on, use your discretion. Is there anything wrong with, again, me, Allison, and Bruce, board members, and me emailing the two of them to confirm that the meeting is tomorrow night at the public library? I don't think that's a problem. I don't think it's a problem to distribute information in some cases. Again, the line is, have you crossed over into discussion, deliberation, debate? And if the answer is yes, then it's most likely a meeting and you probably shouldn't be doing it.
Even if you do updates weekly?
So you update the owners of what you did as a board in a meeting?
Yes, and what projects are still being considered, what projects aren't doing so well, that kind of thing. It's just something I do.
Yeah, updates are great.
Because
But
let me just, the reason we do the updates now, I do them so often. When I used to be the board member earlier, back when I first moved here, first of all, there's only 10 buildings. And there's really sometimes it's 14 of us that live here, and they are all owners right now. But the board before, the previous two boards before me, they decided that monthly meetings didn't work for them. So they only wanted to meet, when an issue came up.
I see.
And so they would meet, and of course it was during the pandemic, so they would meet outside.
Yeah.
And they would talk, and I would hear them through the window, and I go,
Oh,
but I
boy.
don't say anything because I'm not on,
Yeah, understood.
So we did, people still want to keep the meeting, so because they're considered open, nobody wants to do a monthly meeting.
Yeah,
So,
that's tough.
we just let people
yeah.
email us.
Yeah. Bruce, I'm gonna plow through and then let's kind of track these Q&A questions as we go, because I think.
Right. Okay.
Now, let's talk about what quorum is. Quorum is the minimum number of folks that need to be present in person or proxy in order to have a valid meeting. Here's an example. This set of bylaws says 10% of the total membership must be present in person or by proxy for quorum. Here's one where it's, this is for the directors though, a majority of directors. So you're always going to have two different quorum requirements. One for owner meetings and one for directors, okay? Now, I keep saying in person or proxy. Let's talk about what a proxy is. The best way to think of a proxy, it's kind of like a power of attorney. You are giving someone else authority to act on your behalf. Now, there's different types. So let's say Bruce and I are neighbors in our association, and I'm going to be on vacation at the annual meeting. Now, depending on how much I trust Bruce, I could do a few things. I could do what's called a directed proxy. So it says, I, Kevin, hereby appoint Bruce Lepore as my directed proxy and instruct him to vote yes on motion 1 and for John and Debbie for directors. In other words, I'm saying, Bruce, go to the meeting and vote this way on these issues. One of the problems, though, with a directed proxy, and it's the same problem with absentee ballots, is that the whole point of a meeting is to change people's minds and to have discussions. And so sometimes it happens, you direct someone or you do an absentee ballot that says vote yes on this motion, but by the time the motion gets put to a vote, it's been amended and changed. So in general, find someone you trust. So I trust Bruce, I give him a general proxy. General proxy is Bruce, go to the meeting and vote any way you see best on my behalf, okay? Now, what I could also do is if I don't trust Bruce to vote at all, I could just say, here's a proxy, Bruce, go to the meeting, and you attending with my proxy, counts toward the quorum requirement. So when Bruce shows up to sign in at the meeting, he signs in for himself, and then he also signs in on my behalf as the proxy holder, and I'm the proxy giver. So that counts toward your quorum requirement. Now, there are requirements for proxies. Sometimes your bylaws will say what needs to be in the proxy, but in general, name, association, meeting date, signature, all of that. But here's a one. This is my third trivia question. Let's say Bruce checks into the meeting with my proxy, and it turns out I didn't go on vacation, and I show up at the meeting right after Bruce checks in and submits his proxy. What does that do to the proxy that I gave Bruce, me showing up?
Cancel.
Yeah, it revokes it automatically.
Yeah.
Now, Bruce, and what are you guys chuckling about? Am I missing something in the,
Your
Your slide.
slide is hysterical.
oh, yeah. So, you know, the software, oh boy, I didn't see, that's gonna.
Did you
hurt.
look
I
at
didn't-
it before you put it in your thing?
Nope. No, and so that's too, so the software I use, you put in the words and then it automatically, so it looked at the word meetings and suggested this photo. I gotta update that one. So, okay, whoops.
Let me ask you something about proxies.
Yes,
So let's just say that you do trust me, but you don't trust me very much. So you give me a directed proxy that says how you want me to vote for the directors. And then I go to the meeting on your behalf. I show up, I show the secretary of the proxy, and then I cast a ballot for other directors that other than the ones you directed me.
I have a claim against you. I could and I would sue you, Bruce Lepore.
Should the association accept my vote?
Well, here's the question. Most associations don't record if it's directed or monitor whether the proxy holder is voting. So generally, the association's obligation ends if the requirements are met. I don't think there's a duty unless someone whispers in the ear that there's some fraud going on. But no, I don't think that the association needs to be monitoring that. But let's say they did. Should they accept the vote? Yeah, and then I would sue you.
I think that's
Now,
right.
here's another
You
one
would
for
lose-
you.
You would lose when you sue me, by the way.
I know, probably. Just kidding. Now, here's another one. Let's say, again, I'm gonna go on vacation and I give Bruce my proxy. But then the next day, and this is still the week before the meeting, I run into Allison and I give Allison a proxy for the same meeting.
Ooh.
And both of them show up, hand the secretary of the proxies. Which proxy does the association accept?
Allison's, of course.
Why?
She's Allison.
Because you always accept the later dated proxy.
Oh, that's good to know.
Yeah. Now, Bruce, that reminds me of a joke. Often in these presentations, I bring up a hypothetical and I say, okay, husband and wife, owners of one lot, the lot gets one vote, and husband casts vote yes, wife casts vote no. What do you take? Which vote? And my answer, do you know what it is? You always take the wife's vote. Always. There's no authority for that. That's just, otherwise you end up in therapy or a divorce. Just try not to disagree on HOA votes for those of you that are co-owners of properties. All right. Let's talk about vote. By the way, buckle up, folks, because in about 5 minutes, we're gonna do a fake meeting kind of, and it'll knock your socks off. Now, when it comes to voting, Robert's Rules actually identifies more than a dozen methods of voting. There's written ballots. With technology, there's electronic ballots. There's voice votes. All in favor say aye, all opposed say nay. There's raise of hand votes. There's roll call votes, where you literally read through the roster of all the members, you read their name, yes, no, and you record that. Now, depending on what's being voted on, you may want to use a written ballot. You may want to just do a voice vote. Generally, at annual meetings, votes for directors, anything significant or important or that someone might challenge, do a written ballot so that you have a paper record of it. Other stuff, simple stuff like a vote to amend a main motion. If it's a small group, just do a voice vote. If it's close, then do a stand-up vote or a raise of hand vote. There's lots of different ways. Norm Harker says, if you own 2 lots, do you get 2 votes? That is correct. And
That depends.
yeah, I was gonna say, we just saw some documents that were very unusual. But I know my dad CCNRs very well. So yes, he owns 2 lots, he gets 2 votes.
Unless your name is Norm.
Meeting minutes. Now, at the beginning, I joked and said, remember, they're minutes, not hours. There was an association, I used to go to their annual meetings for quite some while during litigation, and they actually had a court reporter present, and there was a full transcription of the entire meeting. That's a little crazy. What Robert's rule says, here's all that should go in: the motion, whether it passed. That's it. You don't believe me, do you? Now, Oregon has a requirement that you put which way each director voted. But yes, there's the prefatory material, when the meeting starts, the location, the date. But really, the meeting minutes are a record of actions, not discussions. And so here's the problem I have when meeting minutes have a narrative of what all the directors talked about leading up to the vote, is that often when it comes time to approve the last month's meeting minutes, usually inevitably there's a director that says, that's not what I said, let's change. And so you end up spending the first 30 minutes of a meeting arguing about whether the previous board meeting minutes should be approved. And here's the other more important reason in my mind. When it comes to meetings, and it's the same reason that I object and generally do not recommend recording meetings. It's because the whole idea of these meetings is that people should feel free to speak openly, to engage in civil dialogue and discussion. And most humans, if there's a tape recording sitting there, tape recorder, or they know that there's a narrative verbatim, are more reluctant to speak openly. And I think that defeats the whole purpose of these meetings. Now, on our website, we've got some sample community association meetings. By the way, those of you, my colleagues, did you see that the Boones Ferry Terrace HOA meeting that's my homeowners association? I got recalled in a coup d'etat last annual meeting, and I'm going to go back and retake control. No, I'm totally kidding. It is my HOA, but there's like 20 of us, and our dues are $40 a year. But so
Can you get banned from the meetings?
twice. And then I thought, well, now that we're going to do Zoom, try to ban me now. But apparently you just click a button and kick me out easily. So I don't know what to do anymore. So now we're going to, here's, folks, if you thought, if I seem excited about this topic thus far, here we go. Now, let me tell you a little story. There's this guy. He is born in England, comes over to the United States as a child, joins the U.S. the Army. He fights in the Civil War for the North, and then wants a quiet life and goes west to Portland, Oregon. And he's a member of this church. The church is still here in Portland. And he would spend a lot of time at the church, the community meetings and you know, the social stuff, plus the Sunday worship and all this. And he would just hang out in a lot of these meetings at the church, and he got really frustrated. I'm having some audio feedback, aren't I? Am I? Can you hear that? Can you mute?
I heard it, but now
It's gone. Okay. So he gets frustrated, and no offense to anyone, but it was often these groups of these sweet older church ladies, the social committee. And he'd get frustrated because they would hang out for 3 hours, and at the end of the 3 hours, no decisions were made. There was a lot of fun discussion about social things, but no decisions. So one day he starts to write down everything that he knew of parliamentary procedure, and it gets published in a book called Robert's Rules of Order. And his family still owns the copyright. It is in, Bruce, will you hold up your copy? This is the newest version. There we go. And the book, it's a nice size. I always have 3 copies of the current edition, one in my car, one in my office, and one by my bedside. Okay. Now, Robert's rules, and just hang with me for a minute, boils down to 4 things, literally just these: motion, second, debate, vote. Memorize this, because this is Robert's rules. Motion, second, debate, vote. Now, you might ask, well, Bruce, hold that book up again. It's at least 2 inches thick. And so some of you might say, Kevin, you are off your rocker to say that that 2 inches of book is really this. And of course, I'm exaggerating to some degree because Robert's Rules gets into some real nitty gritty. For example, when a motion is made, who gets to speak? Well, Robert's Rules says you rotate between those for the motion and those against the motion. Those that haven't spoken get higher priority to speak than those individuals that have spoken. So there's all these nuances, but by and large, 99% of Robert's Rules is this, and I'm going to show you in action in just a minute. Now, for small boards, now here's another thing about Robert's Rules. It is designed to control large groups of people. In fact, I'll tell a little story. It's how I met Bruce Lepore. There's a lot. How many lots are at that subdivision that we met? 1,000, 1,200?
A little bit over 1,000, I think.
Over 1,000 lots. And he was managing. He wasn't even a lawyer back. You might now, some of you know Bruce, you might think he's been a lawyer for a long time. He's pretty long. But when I first met him, he was managing this association. And I was asked to chair this meeting. And so that's Bruce and I met in Bend, and we drove over to this subdivision. And we were a little worried because there was an owner there that for the last 6 months had gone around collecting proxies. And I saw her get out of her car with 2 boxes of proxies. She had got enough proxies to overthrow the current board, elect her allies. And then the first 2 items of business, they fired Bruce and they fired me. But I will say this, it was a beautiful, well-run meeting. So here's what I did. There was tension in the air. Actually, just before at a board meeting, there was a physical fist fight between 2 board members, both in their 70s, old sweet ladies. It went to punches outside of their meeting. So I thought this could get crazy. So I stood up and I said, here's what we'll do. And I kind of went over some ground rules. And as soon as I went over the ground rules, I said, listen, does anyone object? And it was in a big firehouse. I don't know, there were probably, I don't know, hundreds of people there, and everyone, and Bruce, that's when you were like, this Harker guy knows how to run a meeting, huh? Because it went well.
Yeah.
Thank you.
I mean, it all.
This
depends
is
on what you
recorded,
mean by
right?
went well.
So, yeah.
No, it did. You're right. It did go pretty well. And yes, you handled it fairly well.
But it's only because, and I promise you, any of you, if you spend a couple weekends, and I always tell people, don't start with the actual Robert's Rules. Get Robert's Rules for Dummies. I'm serious. Because the best way to learn this is to do hypotheticals. So Robert's Rules for Dummies will have these hypotheticals, kind of like what I'm doing tonight, and then explain how that decision ended up. So it's a great way to learn. There you go. Here's another one. Is that Jim Slaughter?
Yeah.
So if you go into Amazon and search Jim Slaughter, he's got tons of references, and he is specific to HOAs and condos. So all of his Robert's Rules stuff is designed for you folks, not necessarily for corporate America. So that's the reason I love this topic is as a lawyer, my very first law conference I went to, I saw him speak, and I thought, I did not think that parliamentary procedure could be this sexy. That's not the right word, but it's fascinating. Okay. Now, for
Underrated.
small, what's that? Did
I
someone
said
say they agree? Now, for small boards, there is a different set of rules that are a little more laxed. For example, and a small board under Robert's Rules is 13 people or less. Most of your board meetings will qualify for that. But again, use your discretion. Sometimes you want the formality, especially if there's tension among the board. But, you know, if most of your board meetings are in someone's living room and only a couple of owners show up and you have coffee and cookies as part of it, you don't need to be a stickler and yell out, we can't proceed because that motion wasn't seconded. Well, for small boards, Robert's rule says that's okay. You can be a little, my generation, us young folks, we say chillax. That's a combination of chill out and relax. Just chillax. You don't need to do these formalities. Now, on our website, there is a little chart. And some of you, and it makes my heart warm when I go to board meetings and I see that you have printed this out. I've seen some of you laminate it. And if you want, I will sign it, you know, if you want, like a original. But this isn't a hierarchy, okay? And in a minute, after we go through this little exercise, this is going to make a lot of sense. Now, here we go. By the way, I put I put this, I was so impressed. This was back before PowerPoint really. So this was a technological feat when I first did this, because you're going to watch this little bubble. Oh, no, I'm not in play mode, so we're not going to do the bubble. Never mind. Okay. Here's our fact pattern. We're at an annual meeting, and we are all owners. We're all neighbors, and this is our annual meeting. We've checked in. The chair has started the meeting. Quorum has been verified. And we're now on new business. Okay. And Ken stands up. And by the way, I'm the chairperson of this meeting, of course. Ken Miller stands up and says, I make a motion that we spend $100 to renovate the clubhouse. Now, remember this, folks. Motion, second, debate, vote. Okay. Motion, second, debate, vote. We have a motion. Now it needs to be seconded. Now, Robert's rules. Do you know why you need a second? All a second does is indicates that there is at least one other person in the assembly that is interested in talking about this issue. So at an annual meeting, if Ken makes that motion and everyone is just sick and tired of Ken because he's making motion after motion and no one seconds it, guess what? As the chair, I say the motion dies, no second, and we move on. But in this one, and by the way, I'm just going in order on the screen. Toby seconds it. So now we have motion, we have the second. So at least one other person wants to chat about it. Then we go into debate. And I use debate and discussion interchangeably. So again, motion, second, discussion, vote. Now, we're in the discussion and we're having a lively debate. What is it, the roof that needs to be fixed? Is it the siding? And is $100 enough? And sure enough, Andrea stands up and says, I make a motion that instead of spending $100, we spend $2,000. Now it's the same thing. Motion, second, debate, vote. So it gets seconded by Connie, and then we go into the discussion. Now, in this discussion, all we're discussing is, should we amend Ken's motion to $2,000 instead of $100? So assuming this passes, that doesn't mean that no money is being spent yet. All we're going to do is amend, and now the motion, Ken's motion, instead of $100 is now $2,000. It gets discussed. I, as the chair, say all in favor. It gets approved. And now we're back to debate on the now amended motion. Now, if we go back to this hierarchy, look at the very bottom of this, a main motion. That's the lowest motion in Parliament, in Robert's rules, okay? But look, motion to amend. So if we're on a motion to amend, the only motions that can be made at that point is anything above this. So if we're on this motion to amend, and then Kathy says, I make a motion that we hire an accountant, I would say, Kathy, that's out of order because that's a main motion. And we have an amended motion that's pending, and therefore it's out of order. So let's say it gets approved. Now we're back to debating whether to spend $2,000. Now let's say Bruce stands up and says, let's table this because it's getting close to noon, and you know me, my blood sugar gets low and we need to eat. What should I do as the chairperson at that point? I'll tell you. I'll say, Bruce, under Robert's Rules of Order, your motion is out of order. Because a motion to table cannot be made for inappropriate purposes like you're hungry or bored. Now, if Bruce makes a motion to table because we need to spend more time, hire a contractor, have an inspection done, get bids, that's appropriate. And then I would say, fine, we'd go through the same process, motion to table, second, debate, vote. But in this case, I'll say, Bruce, that's out of order. And then we move back to the discussion of should we spend $2,000? Now, let's say in the middle of this discussion, Lenore stands up and says, I have a point of order, Harker. I think you're wrong when you denied Bruce's motion to table. Can she do that while we're discussing and debating a motion? Yes. This is one of two motions or things you can do that always stop the meeting, no matter what's going on. A point of order is one of those. So if the point of order is made, let's say that I'm not a brilliant parliamentarian. As the chairperson, I can pause the meeting, I can call legal counsel, I can search on the internet, I can look at my copies of Robert's Rule. I ultimately come back, make a ruling, and then we move on.
What if you're wrong?
I'm never wrong. No, so if you're wrong, for those of you in Oregon, there's a statute that says, hey, if there's a little mistake in this procedural thing we're doing, you got 1 year to make a challenge. And if you don't, it's deemed approved. And some of your documents have similar language. Great question, Bruce. Now,
Is there anything that can happen at the meeting if you're wrong? If you make a wrong decision about parliamentary procedure?
yeah, potentially. And I'm going to tell you what I would do in just a minute. Don't give it away yet. Okay. So we're back to discussion. Now let's say Gary makes a motion to increase reserves. We can't do it. You can't make a main motion while another main motion is pending. So as the chairperson, I say, Gary, you're out of order, and debate resumes. Now, have you ever seen anyone stand up at a meeting and just yell out, I call the question? Anyone ever heard that, seen that? There's no such thing as that. You won't see that in Robert's Rules. What they're trying to say, what they mean to say, is that they're making a motion to end debate. Now, again, it's the same thing. Motion, second, debate, discussion. So, motion is made to end debate. It gets seconded. Now, it goes to the vote. Now, as the chairperson, especially if the discussion has gone on and on for a while, it's always important that as the chairperson, you restate what the motion was before everyone votes. Because a lot of times, as the debate goes on, people start forgetting what the original motion was. So just always restate the motion before it goes to a vote, okay? And then, because this is so important, I would probably do a written ballot. I would have some tellers, count the votes, I would announce it. And then guess what? Remember that inappropriate motion to increase reserves? Perfectly fine now, because there is no other main motion pending, okay? Now, let's say before I can even get a second on this motion to increase reserves, Allison stands up and says, I make a motion to adjourn. Can she do that?
Yes.
That's right. Because look at the highest motion on this. It's a motion to adjourn. You know what Allison could have done? Way back at the start of the meeting, she could have made that motion. And if it carries, the meeting ends. Do you know why? Because Robert, he was a smart guy. He said, listen, if the majority of folks at any meeting don't want to be there, they shouldn't have to be there. And I've had meetings where there's been a clever owner that comes in and does that, and it carries, and the meeting, it ends right then and there. So, motion to adjourn is made. Now, again, there's some exceptions to this whole motion second debate vote. For example, that motion to adjourn, there's no debate on it. It goes straight from motion second to vote. Most other things, especially any main motion or motion to amend, always debatable. Now, what gets really tricky, and when I'm chairing meetings, I am writing, and when an amendment gets made, I rewrite it, because sometimes you'll be debating a motion to amend a main motion. And unless you've got, my brain operates at a very, very incredible, no, I'm just kidding. Anyway, it can be hard to keep track of sometimes. Did you all like that?
On your slide.
I don't know how, how did I draw on that?
I don't know.
Well, this is perfect. We have 7 minutes for Q&A. Now, I can't tell.
We have a few questions in the chat.
Yeah, will
box
you
here.
start whittling away on those?
Let's see. So the Appfolio system allows for online board approvals for approving maintenance expenditures. Is that considered a meeting? If I'm reading the questions, you have to answer.
No, I was trying to get those things off my slides. I wasn't even listening. I thought you were doing it.
Okay, the Appfolio system, I'm gonna ask you again.
Sorry.
The Appfolio system allows for online board approvals for approving maintenance expenditures. Is that considered a meeting?
It could be. Now, usually like with Appfolio or approval, usually there's already been a motion or some record in the meeting minutes that says, we vote to do this and so has the authority to sign the checks every month. So it really depends on what it is and how the initial approval was made, but in some cases that could be perfectly appropriate.
Yeah, I think if it's a ministerial act, it's sort of, there's already, the board has already voted to approve something, and now it's simply an individual director carrying it out. That's unlikely that it needs to happen at a meeting. That's sort of ministerial action. Now, what do you think, though, about unanimous consent decrees as opposed to, voting at an open meeting?
Oh, Bruce, great question. Here's a great way or situation to use unanimous consent. Board meeting, and you got 3 things that are really procedural. You would simply say, motion 1, 2, 3, anyone object? Hearing none, all approved.
Well, I was
So-
actually thinking, so under the nonprofit
Oh.
corporation, you can have action without a meeting if it's unanimous, if it's signed by all directors and entered into the minutes, you can have an action without a meeting.
I think that's problematic for nonprofits who are governed by open meetings requirements. Now, this is a good one. If you own multiple lots, can you hold multiple director positions? So let's say 2 individuals own 2 lots. Can they both be on the board? Generally, yes. But is it a good idea from a PR perspective to have co-owners serving? Sometimes no. But also keep in mind that almost all cases, directors have to be owners within the community. You can't have a non-owner as a director. But in some cases, you could have a non-owner as an officer.
But just, specifically the question saying, can you hold multiple director positions? One person can't be 2 out of 3 directors.
No, one person cannot. Each directorship is one human being. Yeah.
Can you send out a draft of the minutes prior to the meeting so we don't have to spend so much time going over the meeting minutes prior to the meeting to vote on them? If you mean you're sending out a draft of the previous meeting's minutes, yes, so that you can distribute any sort of materials ahead of the meeting to the directors so that they have it and can review it prior to the meeting, which they're going to act
And that's
on.
and same with annual meetings. Most of you, when you send out your notice of the annual meeting, you include a draft copy of the previous years for approval at that meeting.
So what I was trying to get to is we have our homeowners meeting and we have some votes. We have minutes. Can we send out a draft to the homeowners prior to the question is, the owners have to wait 3 months for it to approve those minutes. And so
Yeah,
how do
I
you
think
feel about that?
Yeah, unless there's something controversial going on, as long as it's clearly stamped draft. Yeah, I get it. Some owners don't want to wait 3 months in between, but clearly mark it draft, and then I don't think
Because
that's a problem.
we're thinking of having another meeting like a week after via Zoom or something,
Yeah.
just to get the meeting minutes approved. And I kind of feel like that might be a waste of time.
I agree. Send out the draft and then do the official approval at the next formal board meeting. Yeah.
Co-owners of one lot can be confusing, especially in small HAs. There's been interest in co-owners being voted in as directors and having 2 director votes, but only 1 vote for the lot.
Mm.
No, that's not allowable. So each director is going to have one vote as a director. And it's not going to matter whether that director has 10, 20, or 30 lots. They're one director and they get one director as one vote as a director amongst the board.
Sarah asked, what is considered, oh, sorry, Bruce, did I cut you off?
Nope. I was just going to read the same question. Go ahead.
Yep. Sarah asked, what is considered a small board? 13 individuals or less under Robert's Rules of Order.
Right, so if the amended decision has been approved, why more discussion? I think that's going back to the, if the owners voted to amend a primary motion, then why do you have to continue debating the primary motion?
You don't. Once the motion to amend is approved, you're debating the new motion at that point. Does that make sense?
In our meetings, the secretary does not take notes or do the meeting minutes. What
Does
should be
anyone?
done?
Yes, like we can only vote.
Somebody should.
Yeah, generally generally that's under the secretary's roles and duties. But
Yeah,
again,
but it is possible for the board to delegate that task to some other director, so or some other officer. It's
Does
not something that's
manager-
written in stone. Yeah.
Bruce, some managers will do that at meetings, correct?
Yes.
So yeah, it can be delegated.
In the course of disciplinary action, a notice sent certified mail is refused. Is it considered delivered?
Depends.
Well, yeah, I mean, I think what they're saying is just notice of a violation. That's, the only requirement actually is to send that just in regular mail. And I think once it's mailed, it's considered mailed. So going back to that folio approval, it should not be used for any expenditures that have not been discussed in open meeting with owners voting, with not owners voting, but with directors voting. That's correct. Yeah. So yeah, you shouldn't be approving the expenditure itself, as opposed to say the amount of money, without that having been a vote of the directors in an open meeting. So we have two types of meetings listed in our bylaws:
I
annual
got this one.
and special.
I read it.
Both of the members. In number 2, I'll read it for the rest of the folks. So just
Sorry.
hang on there, Kev. In number 2, the president, majority of board members, 2 directors, or 10% of members, 3 owners can call a meeting. However, every meeting of the members must meet quorum, which 25% of membership, 7 owners. If quorum can never be satisfied despite several attempts to reschedule, does the special meeting for which members called a vote be dismissed? So what happens if quorum can never be met?
You can't have a meeting. So you can get the 10% signing a petition to call a special meeting, but if at that special meeting quorums are not achieved, nothing, no voting can happen, nothing can happen. Now, Ron's in Washington. For those of you in Oregon, for owner meetings, there's this very interesting statute that lets you immediately adjourn the meeting, recall it 10 seconds later, and now your quorum is 20% or half, whichever is greater. And I know that's confusing. And if you go to our website and just type in quorum, there's a little article on reduced quorum in Oregon. Sorry, I'm cruising through this because we're already after the hour.
I think that's our last question.
Woo! Well, that was beautiful. By the way, folks, I forgot to mention Allison's birthday is Friday. So feel free to wish her a
Happy birthday, Allison.
And last month
One of your HOAs should have a meeting and let Allison come and chair it.
on Friday on her birthday. I can't think of a better way to spend a birthday than chairing a meeting. I'm serious. What a wonderful way to spend a birthday. Thank you, folks. I know we ran through a lot of stuff. I hope you had fun. And we'll we're going to take a break for July and August because it's the summer and most of you don't want to be doing this. You would rather be outside. So we're going to do another big one starting September. And then we'll also be going to be doing this Washington only one. Probably September, Bruce, right?
Yeah, it's not as urgent because
It's Jan 1.
I had thought that there was January 1 of next year that the statute. It's actually not till 2028. So I think it might be better even to postpone it a little bit. But I think a lot of the Washington boards are interested to know what the difference is between
Yeah.
their current statute and Wekiwa, so we'll figure it out.
Well, thank you, everyone. Have a wonderful rest of your evening, and we'll see you in a couple of months. Bye-bye.
Thank you. Have a good summer.
Thank
Yeah,
you.
everyone.